when the world has got you down. And
Alzheimer's sucks. It's an equal opportunity disease that chips away at everything we hold dear. And to date, there's no cure. So until there is, we continue to fight with the most powerful tool in our arsenal, love. This is Love Conquers Alls, a real and really positive podcast that takes a deep dive into everything Alzheimer's, the good, the bad, and everything in between. And now, here are your hosts, Susie Singer-Carter and me, Don Priest.
Hi, everybody. This is Susie Singer-Carter.
And I'm Don Priest, and this is Love Conquers Alls. And we have this is different than we normally have because we have a continuation of a conversation we had.
Yeah, this is a part two of a conversation that we had with a guest that is a elder care attorney. Is that dog barking too much, or are we good, everybody? Are we good?
It just depends if you like the sound of small dogs.
I mean, listen, this is a podcast.
That's right.
All right. Last week we had an incredible conversation, but we ran out of time right, Don? And so we're going to pick this up on take two, and or part two, rather. But we had a very dynamic conversation. So if you're listening to this now, please listen to part one first.
Yes.
Because there's a lot of information, amazing information that you'll want to know. And I did a post last week with Anth. Well, why don't you give an introduction to our guest first?
Anthony Lanzone is the founding partner of Lanzone Morgan LLP, a firm built on courage, compassion, and justice. Earning his Juris Doctor from Western State College of Law, Anthony went on to complete advanced training in dispute resolution at Pepperdine University's renowned Strauss Institute. He's an active member of the Consumer Attorneys of California and the American Association for Justice. Driven by a lifelong passion to stand up for injustice, Anthony has dedicated his career to advocating for the rights and dignity of vulnerable individuals in nursing home and elder abuse cases, and holding powerful institutions accountable. And we are honored to have him back as our guest today, Anthony Lanzone.
So after our conversation with Anthony last week, I did a great post that I don't know if you saw it. I tried to tag him, but about why it's important to at least try to talk to somebody and try to at least get hold these places accountable.
Here's the thing, if you don't do that, if you have a viable case and you don't do that, then you're not holding people to account. And by not holding people to account, you're encouraging the conduct to continue. And
exactly.
So, perfect? Is it going to change what happened? No. Does one case change the world? No. But cumulatively, it has to. And I've seen changes in the industry over 20 plus years. And, just making them more aware, I think, has been a positive thing.
And I got so much response because people were like, we want to know more. We want to know more. So this is a very, dynamic topic that doesn't get talked about enough. And people are under all kinds of misunderstandings. And so we're setting out to try to clear up some of those misunderstandings, as complicated as it is, right? So let's jump into it, Don.
So let us welcome our fabulous guest in our part two, Anthony Lanzone. Hello, Anthony.
Hello, Don. Susie, thanks for having me back.
Well, thank you for coming back. You're a champ of the highest kind. There's my great.
I appreciate that.
Last time we spoke, Anthony, we spoke about the burden of taking the actual why elder care and neglect cases are so difficult. We talked about that, and there's a high burden of proof. It's expensive to litigate. There's arbitration traps. There's systemic barriers like insurance and Medicare and Medicaid's incentives, and on and on and on. And so we wanted to come back and talk to you more about that and dig in a little deeper. And I think, what can you tell us a little bit about how when companies that are taken to court, or if you actually are successful in having a case against a corporation or a facility, or what happens and why and how are they able to declare bankruptcy and get away with that?
Mhm. Well, bankruptcy is part of the legal system, and people that cannot pay their debts or have the right to file for bankruptcy. Now, the bankruptcy have to be legitimate, though. They can't be collusion or things like that. The interesting thing about bankruptcy court is oftentimes there are things that if you're not in bankruptcy court, some of the actions would be considered illegal and actionable. But if you can get a bankruptcy judge to approve whatever acts you're doing, then you can get away with it. And so we have dealt with bankruptcies in the past. And I have a lot of strong opinions about the bankruptcies that I've dealt with in the past. Some have been legitimate, and some, in my opinion, have not been legitimate. And I'm not a bankruptcy lawyer. Every time there's a bankruptcy involving one of my cases, we have to hire a bankruptcy lawyer. That's a whole different universe. And so I don't really know. I'm probably not the best person to talk about the bankruptcies. But I can tell you that the nursing homes are very good at filing for bankruptcy. It appears to me that some of these operators, not all of them, but some, play the bankruptcy game where they operate and they accumulate debt. They accumulate debt and claims, accumulate debt and operations, and they get to a point where they can't accumulate any more debt and operate, at which time they file for bankruptcy. And there's a lot of shenanigans that can go on in the bankruptcy courts. And in some instances, I've had experiences where they file for bankruptcy, get the debts discharged, and the sale of the entity essentially goes back to the owners in a different form, different name. That does happen, and it's part of the legal process. And when it happens, we got to deal with it and try to get the best result for our clients that we can under the circumstances.
Thank you. It's so frustrating. It really is, because
It is.
we hear it all the time, and like these cases can take years and years and years and years. And then this is the culmination of it.
But I would say, Susie, that's the exception. The bankruptcies really are, for as many cases I've dealt with over the years, every once in a while there's a bankruptcy, but it is the exception, and it's definitely not something that I worry about very often when we're litigating these cases.
That's good to know. I mean, from what, I guess from my partner's perspective, the former federal prosecutor, the things that the cases, and I think probably more with the larger, more franchise, like class action suits, those things happen because the stakes are very high. And that I would assume that it happens more often in those situations when we're talking about hundreds of millions of dollars in judgments, at stake. You wanted to talk about arbitration, and I think that people need to understand that as caregivers. Like, what exactly is that? How is it baked into your contract with a long-term care, and how does it actually work? Like, and how is it a negative for the caregiver and the family?
Okay. When somebody's admitted to a long-term care facility, they're given a contract to sign. And in the form of a skilled nursing facility, these contracts are at least 100 pages long. It's a lot of legal jargon. There's a lot of different parts to it. And when they give this document to you, you're in a stressful spot. You're having to make decisions about a loved one's care that you probably don't have a whole lot of experience with. and you're not seeking out a lawyer to review the contract. You're probably not even reading the contract. You don't care. You're just going to sign whatever you need to do because you think you're doing the best thing for your loved one. Make no mistake about arbitration agreements. They are there for one reason, and that is to benefit the provider. There is nothing in there to benefit the consumer. I believe in arbitration agreements, but I do not believe in pre-dispute arbitration agreements. It makes absolutely no sense because consumers aren't able to anticipate what the dispute may be. And 90%, I should say most of the time, they have no idea that the arbitration clause is in there and no one really discloses it to them, and people don't know.
What does that mean? What does that mean, predetermined dispute?
So a pre-dispute arbitration agreement is when I enter into a contract with you and say we're going to do business and we're going to agree to arbitrate any disputes. So there's no dispute yet, but we're entering into agreement that if we do have one, we're going to do an arbitration. That's what I don't believe in. If people get into a dispute after the fact and they want to go arbitrate their claim after the fact, a post-dispute arbitration agreement, those are fine because people are they know what the problem is, they know what their rights are, and if they want to go arbitrate it after the fact, that's fine. But what people don't realize, and here's the big danger in the term of long-term care, is that you're not required to sign the arbitration agreement in order to get the care and services at these facilities. They don't tell you that, but you're not required to. They can't reject you as a resident if you refuse to sign the arbitration agreement. And people need to understand that. You're not required to do that. And I suggest that you don't. And if you're considering it, you need to contact the lawyer about it. I'm not social media savvy, but from what I do, I get out there that, hey, if you are a loved one or about to go to a long-term care facility and they want you to sign a contract, send me the contract. I'll look at it. I'll advise you on it. No charge. Just I want people to understand what they're getting themselves into and what their rights are.
Have you heard of situations where the facility says, "Hey, unless you sign this," I mean, you say they can't do it, but do they go ahead and just say, "Unless you sign this, we can't do this"? And if they say that, what do you do?
I'd say that that's the exception. That's rare that happens. Most of the time, they just try to throw it in the middle of all the stuff. Sign here, sign here, sign here, sign here. And my guess is that the person that's getting the paperwork signed, they're just doing their job and they just want to go through it. And if you say, "Hey, I'm not going to sign that," they're aware that they're not required to do that. So, but arbitrations are a big deal. And we just had a case at the Supreme Court of California last year. 20 years ago, I was on the losing end of a case called Garrison, where the appellate court disagreed with me and said, if you have a healthcare power of attorney and you sign an arbitration agreement, then you have the authority to bind that person to arbitration. And I made it my goal. I'm going to get that overturned one day. And lo and behold, last year, the Supreme Court came down and said, no, a healthcare power of attorney does not give that person authority to sign somebody's constitutional right to trial by jury away. And so, but if you have a durable healthcare power of attorney, that question's still open. The courts have been interpreting that they do in fact have the power to enter into that contract. So it's complicated. And what's really upsetting in the care industry is that it's so unfair because of the circumstances where you're signing all this paperwork. The only thing that these people are worried about is getting their loved one the care that they believe that they need, that they're being told this place can take care of your loved one. They're not even considering the contracts that they're signing or the paperwork that they're signing, nor necessarily should they be. So it's really frustrating when we get cases where these arbitration agreements exist and then you have to disclose to the clients who are already feeling horrible, right? they have this guilt. They're the ones that put their loved one there. They believe in the people in the white coats were going to do the right thing. And then now they find out I got victimized again by an arbitration agreement that I was totally unaware of or what it meant.
Right. So if when you go into arbitration, maybe I just want to go over this one more time. When you go, because I went into an arbitration agreement with a lawyer that was repping my mom when I was trying to get an outside fiduciary to take a look at my mom's accounts because my brother was doing shenanigans. Okay, and she didn't succeed. And then I got like this master bill like 6 months later, as if she was still working for me. And then she said, "Well, you better pay it, or I'll take you to court." And so I said, "Take me to court. I mean, you're done. We were done. Like I don't owe you this money, right?" So we went into arbitration, and everyone, my brother-in-law, who's a lawyer, he said, "You're going to lose because it's all stacked in the lawyer's favor, right?" And I'm just saying arbitration in general. I'm not saying lawyers, but
yeah.
And so it's I won the arbitration because the lawyer that was overseeing it, was phenomenal, and he really caught her in a bunch of lies, and wrote this incredible essay or whatever they submit at the end, their reasonings for, which was so validating. But when you go into an arbitration, let's say I wanted to indict this woman, or at least report her to the bar. I mean, when you go through that, and do you have to win your arbitration in order to go to court? Is that how how does that work? Or what is the process? So let's say you unfortunately signed the agreement and it has an arbitration clause. You go into arbitration and you lose because it's stacked in the favor of the nursing home. Is that it? You're done. You have no leg to stand on?
That's it. Exactly. So I need to explain kind of the disadvantages to the consumer with the arbitration agreement. So number one, arbitrations are extremely expensive. Why? Because you have to pay the arbitrator for their time to make these decisions and to hear the case and hear the evidence, weigh the evidence, and make a decision. The consumers don't know that. And we're talking tens of thousands of dollars. Maybe by the time an arbitration's done, hundreds of thousands of dollars just in costs to the arbitrator. So that's the first consideration. The second one is most of the arbitration agreements and most of the rules of arbitration significantly limit the scope of discovery. It limits the number of depositions that you can take. It limits the amount of written discovery that you can do. Elder abuse and neglect cases are really complicated and really difficult to prove. And the only way that we can do that is having a wide scope of discovery so that we can do what we need to do in order to meet our heightened burden of proof. And so with that limitation, the likelihood of proving your elder abuse case in arbitration it goes down substantially. In addition to that, arbitration, one of the reasons why the defendants want to go there is because they feel as though it takes the risk out of a big damage award like a jury would give, right? And the reason why they think that is because, generally speaking, arbitrators are retired judges or retired lawyers. Lawyers tend to have seen it all before, right? They've been the judge and they have seen this before, so there's no shock value. Where when you have a jury and you show a jury a stage 4 bed sore and explain to the jury how they got this through some type of reckless conduct, that has a lot of shock value. And so, again, arbitrations are there for one reason, just to protect the defendants from these things that they're worried about when they have to approach a jury trial. You're right, Susie. When an arbitrator makes a decision, they write up their opinion. The prevailing party runs down to court, says, "Here's the opinion, judge." The judge signs a judgment for whatever that opinion says, and that's the end of it. The only way there has to be some type of egregious conduct or something strange about the arbitration. The only way to get the court to maybe change the order, and that is very rare and very difficult to do. And I've never heard of it ever happening, although it's possible.
Okay, so I'm confused. So how does anyone take a nursing home to court if there's always an arbitration agreement? Or, I mean, they seem to be baked into all of these contracts. How does anyone get around that?
Yeah, you'd be surprised. There's a lot of technical things that the law requires of these arbitration agreements, from the color of the font on certain parts of it, to the font size, to specific things that need to be in the contract for it to be binding. Most of the time it comes down to the person who's signing the contract having the legal authority to do that. Most of the time they don't. Or if they have the elderly victim sign the contract, it comes down to capacity. Most of the time they don't have the capacity. And so most of the time, I'd say, again, arbitration is the exception, not the rule, with the types of cases that we do. But we do end up in arbitration sometimes. And, that's okay if it happens. But we'd rather not be there because, again, the deck is usually stacked against the consumer.
So you said that we don't waive our right to trial, our constitutional right to trial, because we agreed to go into arbitration. I mean, once you sign it, but if it's like, okay, it's time to go to arbitration, can you just say, no, I'm not waiving my constitutional right, I want to go to trial instead? Or how does that? Or you've signed it, that it must go to arbitration at that point?
Yeah.
Because at what point?
Don,
you're only saying that happens before you sign it. You can say, I'm not going to sign this because I'm not going to waive my rights to trial. Is that correct?
Correct. If you sign a binding arbitration agreement, there's no takebacks. You are stuck with that to the end, and you do waive your right to trial by jury. Which I don't know why anybody would want to do that, to be honest with you. I just, that's the whole system set up for that. And people that come up with these alternative forms, they may make sense for certain business type transactions, but consumer arbitration agreements generally are just unfair to the consumer. And so you just got to be wary.
Doctors, we see it when you go to a new doctor. I know I just had surgery earlier this year. And I mean, I just remember like every one of those pages says, we go into arbitration. I mean, it has an arbitration agreement.
Yeah.
And I'm always think about that, and I'm hesitant. And I think, well, I don't think they're going to operate on you if you don't sign that.
Yeah. Those arbitration agreements too also say on the agreement that it's not a requirement to receive the care. And I'll tell you a personal experience. I had a problem with my eye, and I was in so much pain. And I went to this ophthalmologist because my optometrist referred me to this person. And there was an arbitration agreement, and it said right there, you don't have to sign it to get care. And I told the lady at the front desk, I said, I'm not signing that. And she argued with me. And I said, it says right there, you don't have to sign it. And I was in so much pain, I signed it. Gave it back to her, and then it also said that you have 30 days to withdraw your signature, your agreement. And so just the next day, I wrote a letter saying I withdraw this.
And that's all it takes is a simple. It just takes a simple letter. There's no other forms you have to fill out. You just write a sentence saying I'm rescinding my right or my option.
Correct. So long as the arbitration agreement says that. You have 30 days to withdraw your authority. So long as it says that, and most of them do, then that's all it takes is, you want something in writing.
But it's so weird how if all of these offices have these and include them, and most of us sign them because we're in pain, or we're not thinking, we're signing the papers and we're talking to someone and we're just not paying attention. And then some malpractice happens. How do malpractice? I know I'm getting off the topic of nursing home, but how if there is abuse and neglect in the nursing home and you've signed it and it's obvious, like how it just seems like who would ever have the right to take somebody to court then if it's already baked in and you don't know about it? Like none of us do until they hear this episode. Until Love Conquers Alls.
Yeah. Well, I mean, like I said, the arbitrations are the exception; they're not the rule. And we've done arbitrations before, and my clients have been able to get hold people accountable in an arbitration as well. It's just not the forum that you want to be in for all the reasons that I stated. It's not the end of the world, but generally speaking, if you have a really strong case with real egregious conduct, you're probably going to do better in front of a jury than you are with an arbitration. But again, it's not the end of the world. You can still, seek justice in the arbitration world.
And when you said, it's expensive, arbitration is expensive, who incurs those expenses? Is that the facility or the resident? Yeah.
So most of the time, the arbitration agreements will say that the parties agree to split the arbitration fees. Sometimes I've seen arbitration agreements that say the defendant will incur the arbitration fees, but again, that's rare. But the cost.
If you see that, folks, that's when you run. If it says that that's when you go, this place is horrible, get the hell out.
I don't know. It's just expensive, and people need to understand that. And they need to understand what they're signing, and it's just a shame that these places take advantage of people's duress to kind of get what they want.
So let's say I've signed it, and now I'm going to arbitration. I don't have a lawyer. I'm just me. I assume you would recommend people not go into arbitration without a lawyer. Susie did. She went against a lawyer, just herself, and she won. But that's a little different situation. Then now, because when you do a case, you're on a contingency. You're like on a 30 or 40%. But in this case, does that still exist, or how do you handle when somebody comes to you and says, "I have an arbitration. What do we do?" Or "What do I do?"
Well, number one, if you are litigating a case of elder abuse, neglect, or anything, I highly suggest you have a lawyer. It's complicated. In arbitration, you definitely need a lawyer. I mean, nobody can deal with all the legal intricacies of these cases on their own. The arbitration. I'm sorry, Don. Can you repeat?
No, I was just saying, there's obviously going to be a cost to that. Your time there's going to be a cost to that, because in the arbitration there may be no monetary, you may not get anything. I don't know how that will work.
Right.
So there will be a fee involved, and it's different than if you took on a case and said, we're going to either go to trial or we're going to settle, and that's where your fee is coming from. So
there are lawyers out there like me that will do arbitrations on a contingency fee. It's just an extra added exorbitant cost. But there's a lot of lawyers that won't do that. And so arbitration, again, is another example of how it impedes accountability and justice, because it just makes it that much more difficult to find a lawyer to pursue the case, because it is an arbitration.
What's your recommendation to somebody? I mean, you're you, and they may contact you, but you're not going to be able to handle every case in the United States. How do they find the right type of lawyer for that? What's their best path?
Get on the phone. Picking a lawyer is probably one of the hardest things to do. And I always encourage everybody that comes to our firm, I always ask them, have you talked to other lawyers? I need you to go out and do your legwork to find the lawyer that you're comfortable with, because we're dealing with very sensitive, emotional types of cases, and you need to be comfortable with the lawyer, and the lawyers aren't going to come find you. You got to go find them. And so talking to your friends, your family, referrals are great from other folks that know the lawyers. And so that's the only way to do it, is you got to do the legwork. Kind of like healthcare, right? You got to go find the right home for your mom or dad. You got to go find the right assisted living place, find the right doctor. They're not going to come to you. You're going to have to go do the legwork for sure. But with technology now, it's pretty easy to find that particular lawyer with that specialty, regardless of what it is. And, usually there's a lot of reputable people out there that you have easy access to identify who they are.
I have a question. So in your practice, you were focused on elder abuse and neglect. Is your practice the same as when someone is alive and there's, say, financial elder abuse going on? Is that something that you also focused on?
Yes. One of the difficulties with the financial abuse cases is, we get a lot of calls about that. And one of the difficulties is when you're dealing with like the phone scammers, when the elderly folks, put money into an account somewhere, when you're dealing with the contractors that say, hey, I want to put solar on your roof, give me 10 grand, I'll come back and put it on. Those cases are really difficult because it's really difficult to get the money back once it's gone. It goes overseas, or it is overseas. That makes those financial elder abuse cases really difficult to do, Susie. And it's a shame. I can tell you a story. We had a case where a home health agency put a caregiver in a elderly woman's home who had hip surgery. And she was going to be, there for a couple months. And then, all indications were the elderly woman was going to be fine. Well, what happened was the caregiver started opening the mail and found that she had a bunch of money. And so the caregiver kept the woman drugged up for an extended period of time, all the while she's stealing the money. And the granddaughter somehow was in Florida or something, contacted us, and we got involved. And in that case, we were able to get the money back because the caregiver was working for an agency. So she was employed by somebody that was a reputable business owner that had insurance coverage for this type of thing. And we were able to get that money back. But the majority of the time, people hire independent caregivers, don't know where they're from, don't know what their experience is, and they'll take the money and run. You never see them again. And so the financial elder abuse cases, when people hire us, they're hiring us to get their money back. And if if it doesn't make, if all odds are that we're not going to get the money back, it doesn't make any sense to pursue a civil claim. So we have to be wary of that when we take those cases. But they're just tough. I'm telling you, this financial elder abuse.
They're tough. It's really tough because, again, in every sector of elder care, there's such a bias against the actual person, against the person that you're litigating for, or right, like you're trying to protect. Like, I was my mother's conservator person. I sought it legally. I went into court. I was granted that because my brother had changed my mother's individual will into a living will with my stepdad, which I know she didn't want, but she had Alzheimer's. And he made himself trustee, where we were both trustees on my mom's, power of attorney, equal on her will. So I didn't know it until I had to know it. And when it was necessary for my brother to do his fiduciary duty, he wasn't doing it. And so the lawyer that took me to court that I had to arbitrate said that we would file to have him removed as fiduciary and ask the court to grant us the right to hire an outside fiduciary, because I didn't want the job. I just wanted it to be, I wanted to know what my mom had. So, because I was taking care of everything, I didn't even know what was there for me to be able to take care of her with. So, when we went into court the first time, the judge said to the lawyer with me, "You don't have standing." And I didn't understand that. And why didn't my lawyer understand that I didn't have standing? We went back again and we still didn't have standing. And then my lawyer said, "I can't do this for free anymore," meaning because she was going to get paid from my mom's estate. And I said, "Well, I've paid for all the filings like you told me, and now you're leaving me like stranded." And she said, "Well, you either have to pay me or, bye." She gave me a nice coffee mug. And so I represented myself in the courtroom, and I did everything. I mean, I'm a pretty good student, and I did my due diligence, and I had every reason why my brother was not doing his fiduciary duty. I never got a chance to say anything because my brother hired this really high-powered litigator who said, if Susie tries to get power of attorney, or we're going to go, she's just not going to get it. No, not power of attorney, standing. Because I still, by the way, number 3, I had no standing again. So she said, if she tries to get standing, we'll stop her. We'll try to stop her. And I'm very expensive, meaning my brother would, deplete all of my mom's funds to stop it for no reason. So I cut my losses and I just said, it is what it is. If I have to support my mom, then whatever it is. But how is that, first of all, how does a lawyer like this lawyer that represented me not know that I don't have standing? And why don't I have standing?
Okay, those are really good questions. And I feel highly uncomfortable commenting on that case since I don't know anything about it.
Why?
other than what you just told me.
Oh,
but something that you did say, Susie, that I think is important that I wanted to bring up, and it's kind of on topic.
Okay.
All these problems that you had with your brother and all the estate documents and all that stuff. Did you ever have the opportunity prior to your mom, while she was still capable, at least, have that conversation with her about, hey, Mom, what's the will say? What's the trust say? What's the power of attorney? What does this mean?
Yeah.
What do you want to happen when this happens? What do you want to happen when that happens? Did you and your family get together and do all that?
Yeah. Yeah, my mom was like, "Do not commingle my money. I don't want, my husband's children to have, any, opportunity to take your inheritance, basically. I don't want that." And, that's just something she didn't want. And I knew that. And then when my brother told me that it was much easier to have a living will, a living trust, that, it just makes the process much easier. I believed him. But so I didn't go, and I just didn't. I was so overwhelmed with caregiving at that time that I was like, "Oh, that's going to make it easier, fine." But I didn't know that he took me off.
Yeah.
And made himself trustee.
The point that I want to make is, and I'm guilty as charged because I haven't done this yet either, because it's nerve-wracking. But I think that estate planning should be a family affair, meaning.
Yeah.
Whoever the beneficiaries are, whatever the trustees want to happen, they should be part of that from the time when whoever's gifting this stuff or whatever it is makes that decision. Because if you're reading legal documents, they're complicated. And most of the time people aren't lawyers and they just want to do right by their loved one when they're gone or while they're here, when there's power of attorney involved. You got to make healthcare decisions like you had to deal with all that stuff. Having those conversations while your loved ones are capable of having those conversations, I think they go a long way. because it gets everybody on the same page. Unfortunately, in your instance, Susie, that's kind of different. You got taken advantage of for sure. But I think the vast majority of people would benefit from that, so that when there's an event like a heart attack or something, you got to go to a nursing home. The person making that decision has already had those conversations, and they have an understanding of what the loved one wants under those circumstances. And it takes all that angst out of it, because you're not having to interpret legal documents and what does this mean and what do they want. And I think that would go a long way in just prevention of a lot of this type of stuff that I deal with, because it would have all been kind of talked about and dealt with up front. And so that angst that you feel when you're getting thrown arbitration agreements and 100-page contracts, and I think would make people a lot more aware
and amenable to being aware.
Yeah, and a lot more diligent in their efforts, where they could really take the position of more of an advocate right off the bat, as opposed to, a deer in a headlight trying to make these decisions and figure everything out while it's going on.
Sure. Yeah, no, a crisis is the worst time to make decisions. Yeah. I mean, that is the best case scenario, what you just said. However, we do know that families, are not immune to doing, the wrong thing, even if those decisions have been, predetermined, like what my brother did, which was, not a good choice. So, and I hear it all the time. We talk about it, on Love Conquers all the time, about family members that, make decisions that are not the best for their caree, but rather for themselves. And, and so that's a problem legally. I don't know. It's just, it's just as much abuse as, getting a stage 4 bed sore, in my mind, because if you can't support the person that you're caregiving for with the money that they've accrued themselves, and that's what it's there for, then that is abuse, and that is taking advantage of someone who is vulnerable and may not be able to speak up for themselves,
I agree.
Especially, yeah. So, I mean, do you get a lot of those cases, or is it just me?
No, we get so many calls, Susie, about exactly what you're talking about, and it's not what we do. And in fact, like, I have other people that I trust that I refer those cases to, and to my surprise, they're so busy they can't take on any more work. That's how crazy it is right now with all this estate litigation stuff. It's unreal, all the disputes go. I mean, and it's not a surprise, because you have all this wealth from the baby boomers getting transferred, and it's just gonna go on and perpetuate itself. Just as people are getting older, there's going to be a ton of elder abuse and neglect type cases in long-term care. The trust litigation is just going to overwhelm the probate courts.
I'm telling you, everybody, you have to be prepared. Like Anthony's saying, at least, had I known, and if I wasn't such a, Pollyanna and believed that everybody was doing the right thing, and if I had, been more involved when my brother mentioned that he was going to, bring in a lawyer and do a living trust, I should have been more mature about it and taken more of an active role. And sometimes as caregivers, we're so overwhelmed, and especially if you're the emotional caregiver, you're the one that's, trying to make everything pretty and nice and make quality of life as best as it can be. And you're the hands-on person. You're exhausted. But you're so right. It's so important to get involved in those things that maybe aren't your comfort zone, as it were, and because it'll make your life and your loved one's life so much better and so much easier if you do. And don't let anyone else take over, even if it's your own sibling or your own, spouse or whatever it is, like, and you think that you can trust them. Not to be, I don't know, this sounds terrible, but but sometimes you just have to, the temptation can change people. And I don't know, it's better to just have it clean and clear up front, right?
100%. I mean, I always say, to folks on the other side, I always tell them, if you could just tell the family when they complain about, hey, why is this happening? If you could just admit that something's not going well and just apologize, they probably wouldn't be calling me.
Yeah.
But I understand why they don't do that. They circle the wagons, right? Because they're afraid of getting sued. They're afraid of the litigation. But the reality of it is this caregiving is still there's a human element to it. And if you treat people like human beings, they're going to treat you like a human being too. And so I would probably be out of work if people would start, admitting things aren't going well. But I understand why they do it. And that's the world we live in now, I guess.
It is. Okay, here's a question that people ask all the time. Well, when facilities are fined, if they do get fined, and they often use that as an excuse, like why they're, can't spend money in certain areas. They're worried about fines. They're worried, if they do get fined, which is not the norm, where does that money go? And do the residents ever benefit?
Well, when it comes to nursing homes, the biggest fine that the law allows them to levy is $100,000. But that has to be an egregious case where there's investigations that go on and there's a finding that, this, whatever they did wrong directly led to somebody's death. That money goes back to the Department of Public Health. I don't know what they do with it, but that goes there. Most of the time when there's fines, the nursing homes have the ability to fight those fines and fight the findings of the Department of Public Health. There's an administrative court that they can go through. A lot of them do that when they do get fines. But, I have some strong feelings about the oversight by the state of California and the federal government. It's clear.
Wait, just the state of California? Just the state of California?
Well, I said the feds too. But it's, they don't do a good enough job to protect the public, is as nice as I can say it. The public can't rely on them to hold these facilities accountable. They just can't. A lot of it has to do with the evaluators, their jurisdictions, so to speak. They're not police officers. They're not, they don't have any enforcement authority. So their investigations are really limited. And so I think, as we were talking about, I like to believe that everybody's going to do the right thing and everybody's coming from the same place in terms of that context. But the reality of it is that people aren't. And so the facilities know how to work the system. The oversight agencies seem to not have a whole lot of interest in doing anything other than what's minimally required of them. And the point I just want to make is that take those deficiencies and those citations for what they're worth. If they do issue something like that, where there's smoke, there's fire. That's just
Right.
the big of the iceberg. And just don't rely on the government to do anything. That's one nice thing about the civil courts, and one thing that I do believe is that the court systems can hold people accountable within a reasonable time frame. Where when you're relying on the government to do stuff, if they get around to it, they'll get to it when they get to it. And the sense of accountability that they're, going to administer on these places, it's just not the same. You can get their attention through a civil lawsuit And I think that effectuates change way more than these governing agencies.
See, as you're saying that, I'm thinking about the nursing home lobby. It's just, like how it's manipulating the system to remain the way it is, and to stay status quo, which is, American Healthcare Association, ACA.
There's so much money involved in long-term care. Billions and billions of dollars, the insurance, the Medicare, the Medi-Cal, the Medicaid, there's billions of dollars in it. And business people take note of that. And
Yeah.
it's like the industry's been manipulated by private equity for so long. And I've kind of come to the conclusion that I don't think long-term care was ever intended to be a multi-gazillion-dollar business. I think it was always intended to be a ma and pa who were social
Community.
workers by, they weren't in it for the profit. They'll make a living, but they were really there to be hands-on in each individual home. And they could be in charge of the people that they hire and hold people accountable on a daily. I really think long-term care was always intended to be that model.
I agree.
And, I think that has a huge. That's the big reason why the industry is in the situation that it's in. Is that any way you shake it, there's somebody making billions of dollars, millions of dollars a year, at the behest of compromising care for these folks. And it's really a shame to see it turn that way. And Medicare and the government, they just keep throwing money at them, not holding them accountable. And so unfortunately, I don't see these problems going away anytime soon. But I do hope through like your show and what you and Don do, just making people aware, people can do a lot to protect themselves from this stuff. And I off to you guys for what you do and getting the message out there.
Well, back at you, Anthony Lanzone, because you are a good guy. I can see that. Like, I now know two really good lawyers. Our partner, Rick Moncasso, who I say he's a badass with a heart of gold, and I think you're another badass with a heart of gold. So we really appreciate you, because I have not had luck. And I'm not litigious at all. But just trying to get my mom what she deserved was so difficult, and it shouldn't be that difficult. And it's tough, and lawyers understand that, and they know how tough it is, and that's why it's people like you that will, really throw the starfish back in the water, even though there's so many. You're still picking up the starfishes and throwing them back in the water, because if you help one, you've helped one, which is great. So we love that about you, and really glad that we were able to connect, and that you're able to educate people a little bit more about what actually is the process. And I think the best thing that came out of all of this, notwithstanding that you gave us incredible information, is to do something. And hold the people that are doing these egregious acts to be accountable in some way. At least do that, because our like you said, our Fed and our states are not doing the best that they should be doing. So we have to take it into our own hands. And isn't that like it always is? We have to take it into our own hands, right? If you want something done, you have to do it yourself. So let's do it as a collective. Let's we are bigger than ACA if we all get together, and we're stronger than them. So that's the American Healthcare Association, aka the nursing home lobby. So it's not doable. We can do this, right, Anthony?
I think we can.
Yes, I think so.
Change being made every day. It's slow, but it's, just keep fighting. That's all we can do.
You got to keep fighting. Otherwise, what's the alternative? I think that I love this. And I love everything that has to do with love. And that's why what, John?
Well, that's because love is powerful. Love is contagious, and love conquers all. We thank everybody for watching, listening to our special two-part Love Conquers All.
Yeah.
And I have a feeling there's room for more. So hopefully in the future we can have you back. And because this is not a simple conversation. Yes.
Send us questions. I mean, I think there's more conversations to be had, and take the advice that Anthony gave us in these past two episodes, and I think it's really, really powerful. And I know you're exhausted, but call him. He said it. An open door.
Anytime.
And we'll have all your information on the show notes. Yeah. And if everyone liked what you saw and heard today, please share, like, subscribe. All those good things, and remember
all those good things, and watch No Country for Old People, a nursing home expose on Amazon Prime, and on Tubi, and on Hoopla, and if you're in other countries, you can catch it on Buyer and on Genjing World, and you can't miss it. So you must watch it because it's about you. And I love you all, and we'll see you next time.
Take care. Bye-bye.